Okay, welcome back. We have a great panel up next that I'm really looking forward to. Ever since Joe Grundfest interviewed Andrew Seresny at this event back in 2015, we've been dying to have him back. And today he is back, along with another fantastic panelist, his fellow former SEC Commissioner, Dan Gallagher. So let me start with Professor Joe Grundfest. If you don't know him, you're in for a treat today. He's a professor of law and business at Stanford Law School, a brilliant attorney, has been recognized as one of the most influential attorneys in the United States. Among other things you can thank Joe for is founding the Stanford Securities Class Action Clearinghouse, which has been an invaluable tool for, I don't know, how many years? 20 years now? It's been a while, but great tool. And of course, Joe was previously a commissioner of the U.S. Securities and Exchange Commission. So Joe, we're thrilled to have you back. Welcome.
Thank you so much.
And we're also joined today by Dan Gallagher, who has the stress-free living and job of serving as chief legal officer at Robinhood. Dan has had an amazing career, including being a partner at WilmerHale, chief legal officer at a pharmaceutical company, Mylan, and of course, SEC commissioner from 2011 to 2015. Dan, welcome and thank you for being here today.
Well, thanks, Bruce. It's really exciting to be here and be with my friend Joe.
All right. Well, I'm going to moderate. I don't usually moderate. I usually just keep track of the time, but I'm going to try to do both this time. I'm also going to try to throw some topics out and get out of the way as much as I can. So let's start with ESG, which was touched on briefly in the other panel. But so just to recap, in February, there was an announcement of a newly created position, Senior Policy Advisor for Climate and ESG. And that was followed in March by a 22-member climate and ESG task force in the Division of Enforcement. And the mission of that task force is to identify ESG-related misconduct through data analysis, mining and assessing information across registrants to identify potential violations. So why don't we start big picture here? What are the SEC's efforts related to climate risk and ESG, and what should they be?
Joe, you want me to go first?
Yeah, sure. I think, it's clear they've signaled they're dividing it into two buckets. One bucket is we got a bunch of enforcement attorneys that are waiting to drop complaints on people who arguably are misrepresenting or misstating what's going on with regard to ESG. And more substantially, they're signaling that there's going to be massive rulemaking coming down the pike with regard to additional ESG disclosures and in particularly climate disclosures. Dan?
Yeah, look, and I mean, Bruce, you asked the operative question, what should be the role, or maybe I just read that into your question, of the SEC, and I think it hasn't changed since 1934, right? When it comes to these issues of disclosure, it should be to enforce the disclosure of material information that a reasonable investor would want to have when making an investment decision. And it hasn't changed. ESG has been bopping around for years. It's become a bit of a political issue. It's become a bit of a partisan issue, which I think it does the classification. It's so broad, the things it covers, it does it a disservice, right? There are some material things that fall into the world of ESG that should be disclosed by companies that arguably already were being disclosed by companies, to the best of their ability. And so, I think the focus needs to remain on materiality. It's done us well for 80 plus years. I worry that, we get a little bit of mission creep here. And I do worry that, the agency is run every 4 or 8 years, based on election cycles instead of sticking to the true mandates. And here that would be the disclosure of material information.
Now, young Commissioner Gallagher is exactly right. There's a huge problem lurking in what it is that the SEC might be doing in the future. But there's also a solution that most people aren't talking about. And this is a paper that I'm writing, and I'll probably have it out in the next week or two. So Dan properly focuses on the notion of materiality. All right. Materiality, I'm afraid, is often in the eye of the beholder. And what we know based on letters that have been written by Republican senators to the SEC and states attorneys general to the SEC is that there's going to be blood. There's going to be litigation blood. that whatever the SEC mandates in terms of additional climate disclosure, people are going to sue and they're going to say this isn't really sufficiently material that it should be required to be disclosed. And who the hell knows how that litigation is going to turn out? Because handicapping the outcome of a lawsuit that hasn't yet been filed over regulations that haven't yet been written is a little bit hard to do, all right? But there is one point that I think is hugely important and that I'm going to hope that the SEC pays attention to. And first, let me just suppose I believe that climate change is real. I believe people are causing it. I believe it's important that we address it so that everybody knows where I stand on that. But the best statutory authority to cause the disclosure that we need does not lie with the United States Securities Exchange Commission. It's with the Environmental Protection Agency and the Department of Energy. They have pre-existing statutory authority that can call forth essentially all of the quantitative disclosures that you would want with regard to Scope 1 and Scope 2 emissions. For the SEC to call forward that information will legitimately raise all sorts of litigable issues as to whether those disclosures are material under the federal securities laws. The materiality constraint does not apply to the EPA. It does not apply to the Department of Energy. So my advice to the SEC is going to be real simple. They're going to be basic quantitative disclosures that you want. Terrific. Have the EPA call for them. Have the DOE call for them. Work with those agencies so that you minimize compliance costs, so that they're aggregated up, so that they are consistent with reporting entities, all right, that file reports under EDGAR. And if you want to, you can have them filed as supplements to 10Ks, 10Qs, they can be furnished, all sorts of ways to bring them into the securities law disclosure regime, all sorts of ways to have consistency and commonality without relying on SEC authority. Now, with regard to additional disclosures about how the company's going to respond, qualitative, strategic, there you have to rely on SEC disclosure. It's a whole separate question about how you navigate materiality there.
And there's one issue here, though, Bruce, very specific, I think, to the asset management industry. So it touches on this enforcement effort. And I applaud, then acting Chair Lee, and the commission for putting together this task force. Anytime there's a shiny object in the securities markets, and right now that nothing's shinier than ESG, it would be crypto, except for jurisdictional bounds. But anytime there's a shiny object, we see the rush of money to it. We see the opportunity for fraudsters and scamsters and just regular way rule violators to move into a space to make a buck. And, labeling anything ESG these days is a guaranteed return because there is a demand, right? This is something I actually said in a Squawk Box interview, right? You can't ignore, you can be as upset as you want about, trying to use the SEC as an agent of political change. But you can't ignore the fact that investors want these products. And when they want them, they'll be created. And when they're created, they have to have full and fair disclosure, fair sales practices around them. And you have to have a cop on the beat to ensure it. And you're seeing all sorts of crazy things, right? This such and such green ETF or whatever that has oil companies in it and other things when you actually do the research, right? The mislabeling and mis-selling of these things is something that we really, I think, as a country should want the SEC to be looking into.
And let me reinforce Dan's observations. One of the things that really troubles me the most are the suggestions, sometimes overt, sometimes sub rosa, that by following an ESG investment strategy, you can outperform the market. Well, if that's right, then the semi-strong form of the efficient market hypothesis is wrong. And much of the underlying philosophy of securities regulation and securities disclosure is wrong. And there are really very fundamental reasons, if you just stop and if you think about it, to say, well, it's impossible to outperform the market by adding a constraint. You have to then sort of say, well, wait a minute. It must be that I am smarter than market, because the market as a whole knows what the big push is. We all know how many billions of dollars are going into ESG investment. And if what you're saying is this is going to outperform the market, then you're saying, look, I've got an activist investment strategy that systematically is going to outperform the market. There's so much literature suggesting that that can't be right. Now, you can point to articles that say, well, wait a minute, this strategy has outperformed the market. Very easy response. I've looked at many of these articles. Number one, they fail properly to adjust for other, market factors. Number two, there's all sorts of cherry picking and p-hacking that happens in this space, and the amount of data mining is absolutely astounding. So, one piece of low-hanging fruit that I expect the SEC will go after is anybody who's been saying, look, I can outperform the market by doing ESG investing. I think that's one of the more high-risk claims, and I predict that's where the enforcement division will go.
Excellent point. Yep.
Let's. I thought we were going to have plenty of time. We're not going to have plenty of time.
No, we never
We told you, Bruce. We
I
told
know.
you. Half hours together.
Well, let's
Gallagher
we can
eat up a
circle
half
back
hour
to
of this
ESG
coffee.
in a minute, but let's talk about crypto regulation.
Sure.
Because on May 6th, the new commissioner of the new chairman, Gensler, when he was testifying, said that Congress needed to basically address crypto regulation. He said, right now, the exchanges trading in these assets don't have any framework either at the SEC or at the CFTC. There's not a market regulator around these, and thus there's really not protection against fraud and manipulation. So what are your views on crypto regulation in the first place?
So I'll go first this time, Joe. Look, I think crypto is pretty exciting. As a product offering, as a sort of almost a way of life, right? I mean, if you really pay attention.
I'm sorry, gang. If crypto is your way of life, you've got some real serious.
It is a way of life, Joe. It's like
a
a cult. It's like a libertarian cult, which in some ways, I mean, if you get beyond the buzz and the trading side of it, and you get into why so many people use it and their deeply held beliefs, I kind of find it fascinating. I think from the SEC perspective, Jay Clayton walked into a massive mess at the commission with the proliferation of ICOs. Like 99% or maybe 101% of them were fraudulent ICOs, right? Like it was just like something out of Wolf of Wall Street there with these ICOs, and he had to deal with it, and you had to use enforcement, right? There weren't many regulatory tools or time, quite frankly, to employ the regulatory policymaking arm of the agency. And so I think he spent years doing that. It left us, unfortunately, though, with the lack of a discernible regulatory construct, right? We got a couple speeches, a couple enforcement actions, some here and there. I don't fault Jay. I don't fault that commission, but it's true. That's what we have. And I really do think, whereas the whole industry, all of crypto used to be, stained. Now we're getting into, all right, how do we separate the wheat from the chaff? And it's hard because we don't have those guidelines. So I think Gensler was right in that regard. CFTC has obviously made its grab here or there, but it's more ad hoc, I think, than people would admit. And I think the industry is owed a proper regulatory construct. I think it would be good, as much as the ethos of crypto is, libertarian and get out of my business. I think
buy Dogecoin.
Yeah, I mean, I think that the most folks, engaged in that industry would welcome some proper guidelines, and so I think they should come. I think that with the SEC, it'll obviously have an investor protection angle to it, and but I think without it, we're missing so much innovation, right? We talk blockchain as if we know what we're talking about, and all these other uses. I mean, we could really revolutionize so much of the securities market infrastructure if we would just get better at allowing this new product, crypto, to push us into this new way of doing business. So I hope Gary does it in a incremental way and in a thoughtful way. I don't think it's a market that should be shut down.
Gensler's request for legislation, the way I read it, was a massive cry for help. All right, because I don't think the SEC really knows what to do with this situation in terms of if it had the job to write regulations. All right, and Commissioner Pierce, she's got her proposals, but the probability that would get critical mass at the agency is not huge. And I think quite wisely, Chairman Gensler is saying, look, we need help from our bosses, and our bosses here are Congress. So Congress, you tell us how you want to handle this. In the interim, I'll be very candid. I'm not impressed with the job that the SEC is doing in this space. Right. And by the way, let me disclosure, I'm an advisor to Ripple in the XRP litigation. So I just want everybody to know that. I don't play these games as some others do. So in my view, this is not the set of issues, many issues that should be resolved through litigation. These are issues that you need to face and you need to address through regulation. It's been a battle at the agency for decades over the notion of regulation through litigation. All right. And this, I think, is one of the best examples of a case that's being inappropriately litigated when instead the matter should have been dealt with through rulemaking. Because you litigate this stuff, it's a you're not going to get any guidance for the market. Everything is going to be so narrowly focused on what the circumstances were of this particular case. You're not going to have expert testimony from technologists and all sorts of other people that you need in order to come up with a rational policy. It's not going to help the world. All right. What you need is absent, guidance from Congress. We need clear positions from the SEC to explain what works and what doesn't. And we know litigation will never get you there. And the other thing, I'm sorry, go ahead, Dan.
Can the SEC or the CFTC or anybody do anything about crypto manipulation today? So so yesterday, Elon Musk said they're no longer taking Bitcoin for Teslas. It's not environmentally sound.
It's an environmental disaster.
Right. But let's just say hypothetically, the day before that, he had said to all his friends, sell your Bitcoin. I'm about to tank this thing all the way down.
Well, look.
Is there anything against that?
The short answer is there may be authority at the CFTC side. All right. And on the Bitcoin thing, look, let me go back and do some ancient history over here. When the SEC said that Bitcoin wasn't a security, and they said that it wasn't a security in part because it was sufficiently decentralized, I just sort of heard that and I sort of said, well, this is like crypto amateur hour. What's going on here? All right. Because if you know anything about hash power, all right, and Bitcoin, at that point in time, more than 50% of the hash power resided in China. If you look at the Cambridge University data, approximately 65% of Bitcoin hash power today sits in China. Well, if you've got more than 50% of the hash power, you can cause a hard fork, and in effect take over the entire chain, and you control the chain. Now, as a practical matter, politically, all of the hash power in China can easily be brought under the control of the Chinese government in about a millisecond. So what that means is that the Chinese government has de facto control over Bitcoin. It can cause a hard fork. Now, how is it possible that the SEC says that under those circumstances, Bitcoin is sufficiently decentralized? I don't get it. I mean, is it that they didn't know that there was that much hash power that resided in China then and now? Or is it they knew and they didn't care? Well, if they knew and they didn't care, then what does this concept of decentralization mean? So this one statistic, all right, about the de facto operation of Bitcoin seems to me to really raise fundamental and almost unanswerable. It's one of two things. They didn't know, that's one problem, or they knew and they still thought it was decentralized. Maybe that's an even worse problem. I don't know, Dan, do you have a solution to that?
Well, I mean, I guess it depends on what centralization means, right? And I think that was the Hinman speech with Ethereum, which I know riled the markets again, right? Because he was effectively saying that when it came out, it was a security, but then it became decentralized over time.
Right, but if the Chinese government can force a hard fork in Bitcoin, how is it that Bitcoin is decentralized by any rational definition of decentralization?
Yeah, the standards, again, it's just like I said, I mean, the standards aren't clear. But one thing was clear, Joe, to your point, there was a pretty declarative statement. Bitcoin is not a security. Ethereum's not, but, sorry to touch a sensitive point, but XRP is. And, you kind of, it does hurt the brain when you go through and try to parse these things out.
Yeah, well, when hurt the brain is another way of saying arbitrary and capricious. Just, think about it that way.
Let's move on. So the hearing that Chairman Gensler actually testified at was called "Game Stopped: Who Wins and Loses When Short Sellers, Social Media, and Retail Investors Collide." I mean, I think most people are familiar with that. It was quite a big scene, but to sum it up, some Reddit users, a lot of Reddit users, kind of decided to stick it to some hedge funds by coordinating a buying spree of a bunch of stocks, including GameStop and a few other companies. That caused a huge short squeeze on the hedge funds who were short those, and GameStop went from $20 to $347 and back down to $40 in a couple of weeks. I mean, I'll throw it out to both of you. What are the most important issues in your view that are raised by that GameStop episode, and where do you see things going in terms of any kind of reform?
Well, Joe, do you want me to go? I know a little something about this area.
You do know a little bit. I think the world would rather hear from you first.
So what are the most important reforms coming out of it? If you watch the other two hearings, in fact, the hearing in which my CEO appeared, the focus, a lot of focus on payment for order flow and gamification and a bunch of other things that had nothing to do with the events of January 28th. I think it's one of those things when the mundane nature of what actually happened on 1/28 actually came to the fore, politicians, as they're wont to do, pivoted to other things, mildly, if at all, related things of interest. And market structure is just fraught for that. Equity market structure, right? There's these lingering issues that go back even before the creation of the SEC that just tend to come around every 10 years. Payment for order flow is one of them. Gamification is this yet to be defined but new one. I think, from my perspective, and again, I kind of lived it in a very real, intense way, the number one issue for the commission, and I think for the markets coming out of it, is the settlement cycle, right? The idea that we're at a T+2 equity settlement cycle in the world's we keep saying we're the most advanced capital markets in the world, but T+2 is like 1950, okay? And when we were talking, and I give the commission credit for going T3 to T2 right after I left, when acting Chairman Pivovar was there. But we had lots of discussions about this issue when I was on the commission. I was pushing them hard on STP back then, straight through processing. Didn't want to talk about T2, T1, right? Let's get to same day. Let's get to something real, because what happens is you make a reform and then all the players leave the playing field for the next 20 years, right? They've paid their tax and they want to move on because they're able to pay that tax and leave that barrier to entry in place. So the settlement cycle makes no sense, right? Here on January 28th, we had this massive VAR charge, which has been the subject of a lot of public scrutiny, generated by the risk controls and at NSCC. And I don't debate how they were calculated or that we owed them, but we owed them because the settlement cycle is T+2 days. And what people don't understand, and I had to explain this to SEC officials as well as members of Congress, when Joe comes to me with his $10,000 and wants to buy his 100 shares of GME,
you've got the $10,000.
I got the $10,000,
so
and
you
I'm
don't
gonna
have the additional right. So you had to post risk capital for risk you didn't have.
Right. I took
Joe's
10 grand. Joe, Joe probably came with
pennies. How did that make you feel? How did that make you feel?
A little pissed off,
No, just
Joe.
really.
Joe came with his shopping cart full of pennies. It was $10,000. I put it in the warehouse at Robinhood, right? It's locked up in a 15C3-3 account. I can't access it, that $10,000, right? But it's 100% margin. I wouldn't let him take a loan, which is what we had on all of these positions, by the way, in the meme stocks, 100% margin. Everyone's paying cash if you want to buy. But then while I wait for T+2 at NSCC, I've got to go out of pocket and throw down cash to support Joe's trade. I cannot touch his cash. And so people, right, it doesn't make any sense. It doesn't make any sense as a rule construct, but then it certainly doesn't, make sense for 3 days, right? In a world in which
And it cost you billions and billions of dollars.
Billions of dollars. I mean, look, we had
it added no safety and security to your customers, to systemic risk or what have you. It's one of these things that if you know the plumbing, you just kind of look at it and go, this is Rube Goldberg on a very bad day.
Yep.
All right. This really does not work at so many different levels.
It just doesn't work. And, the computing powers there. Look at what Paxos is doing, right? Yeah. They got a no action letter from the SEC. If you sign up to Paxos, you can do clearance and settlement in many flavors. You can choose T+2 if you're, nostalgic, right? If you like the slow skis as the turtle, that turtle commercial with the dial-up internet, right? If you're the slow skis, you go T2. You can pick real time on Paxos because it's a blockchain, right? Because it's instant, it's a smart contract. The world is going there. I don't want to let the perfect be the enemy of the good. I applaud DTC. I applaud Mike Botson. I think he's a great guy for coming out quickly, announcing T+1. It's going to, for me, cut my deposit requirements in half for my customers. It'll be able to better ensure that I'm up and running, that I don't have some crazy feature like this happen again. And for us, though, right, Joe's point, we had to raise billions of dollars. I now have almost as much net capital in my clearing firm, Robinhood Securities, as one of the big Wall Street firms, right? So that it's bomb-proof. So Bruce, that's number one. I think the other takeaway, is before I burn up too much of my time, the power of the mob, right? The power of the social media mob was my other big takeaway from a risk management perspective. You sit there, you think you're doing everything right, but the power of, in my instance, a false allegation, right? An allegation that we colluded with hedge funds to stop this buying, 100% false, right? Tanked the markets. It wasn't my buy restriction that tanked the markets. It was that false allegation that tanked the markets. And the SEC should be looking at that. And I hope they are, by the way, because that was a pure market manipulation. And
talking about talking about the power of the mob. What about the fact that in the year 2021, you have the technology that would allow, I'm not going to call it a mob, but a group of people on Reddit to move stock prices around crazily. Is there any problem with that, or is that just you got the word out and you got the job done for and the stock went up?
It's so funny. When I was an SEC enforcement intern in the summer honors program working for Bill McLucas, I worked on the Systems of Excellence case, which was, I think, the first internet pump and dump case. And I had to read the Yahoo Finance board all day, every day. I didn't even know what the internet was. There was one terminal on the fourth floor in the old 455th Street building that had the internet. This stuff's been around forever, Bruce. You know it. This is just a bigger, social media is a bigger amplifier, right? It's just, it's more, pervasive.
So Bruce, I actually think one of the more, so Dan is absolutely right. The plumbing, all right, is broken, really does need to be fixed. It imposes irrational costs on innocent people for totally ridiculous reasons. So stipulated, agreed. But the thing that's really different going forward is the evolution of what I call EMOMO trading, emotional momentum trading. And if you look at the basic structure of the securities laws, it presumes the existence of the rational and reasonable investor. That's not these people, all right? The rational, reasonable investor in some sense says, look, I'm investing, I think I'm going to buy low and sell high, or sell high and buy low if you're shorting. But when you're dealing with an EMOMO market, and here it's people who are investing for other reasons and doing it at sufficient scale that it causes a momentum effect. If you have a small number of people getting together and they don't have a momentum effect, fine, all right? But it's when you get this concentrated focus of these people pushing other incentives, all right, other reasons for trading, that the fundamental philosophy, whether it's disclosure or enforcement of the federal securities laws, breaks apart. The whole structure is built on the idea of the notion of the rational investor. That's not these people, all right? And as soon as you break that assumption, everything collapses.
Well, I wish we'd set this up for an hour, but we didn't. So a lot of questions that I would like to ask are going to go unasked. But Joe, do you think you could write a good law review question about a firm that's a broker dealer about to go public, sells crypto, and is right in the middle of the GameStop situation?
No, I don't think anybody would believe it. I don't think anybody would believe that. People
Bruce,
would think that could never happen.
I'm living the law school exam, Bruce.
I know you are. You're working hard.
You got it, buddy.
Thank you both. Terrific conversation. I really appreciate your time and your insights, and I hope the audience got a lot out of it. Thank you.
Thanks for the opportunity. Thank you.